Dave Kopel of the Independence Institute with us on the program. Dave, how are you this afternoon?
I'm doing pretty good right now. We're actually getting ready to file the appeal in the Colorado Sheriff's case today.
Congratulations. Can we talk about that as well while we have you here?
Sure. Now, it's just filing the notice of appeal, which is a fair, it's not a deep content document. It's not the opening brief, which will be months from now. But we're
okay.
it's
what it is.
It's a document that initiates the appeal. So we're on our way to the 10th Circuit.
It is official then. All right.
Yeah.
And now we're still waiting to see whether or not this decision in the case of Palmer versus D.C. will go up to the D.C. Court of Appeals. But we do know that the Attorney General is in D.C. is asking for or will ask for a stay. But as of right now, Dave, and I have to recommend your piece of the Volokh conspiracy because I think it is the most comprehensive look at what the changes are right now in Washington, D.C. To the gun laws with the Palmer versus D.C. decision that was handed down on Saturday.
Yeah, it's assuming that a stay is not granted and or assuming that the district court decision is upheld on appeal. My interpretation is what it means in D.C. today is that on Saturday, the United States District Court ruled that parts of DC's absolute prohibition on carrying handguns in public places is unconstitutional. And then on Saturday or Sunday night, both the Washington Post and Fox 31 DC, the TV station, their reporters announced that DC Police Chief Kathy Lanier, who was acting on advice from the DC Attorney General, had instructed DC Police not to arrest a DC resident who had a registered handgun and was carrying that registered handgun in public places for lawful protection, and likewise not to arrest non-residents who had carry permits.
Okay, so as you point out, though, there are a lot of gun laws that are still in effect in Washington, D.C. So this is not simply a matter of, hey, I can now go anywhere, right?
Oh, there's a lot of places in D.C. you can't go. First of all, federal property is generally off limits for any form of guns owned by citizens, with the exception of National Park Service property, where the law says they're supposed to follow the law of their host states. So my guess is the National Park Service at least ought to follow the procedures of the Chief Lanier has outlined for this period. And likewise, D.C. actually but there's the Federal Gun-Free School Zones Act, and there's also the D.C. has its own version of that, and so certainly that applies on all school property, all the way up to university level, or for that matter, a school of barbering and cosmetology. There's an interesting question in that both of those laws have essentially, not only the school property, but also these enormous zones around them, which essentially encompass the entire district. And how that would apply, that's hard to say. The Federal Act says that you're okay if you have a carry permit issued by the jurisdiction you're in. But, of course, a non-resident wouldn't have a D.C.-issued carry permit, so I'm not sure what becomes of that. Most jurisdictions don't over-enforce in that regard, although New York City does, even against off-duty police or retired police officers who are carrying under the Law Enforcement Officer Safety Act. They may get harassed in New York City for carrying in a school zone.
So let's talk about the decision itself, Dave, because it seems to me, and I don't want to be unkind, but when you look at the decisions that we've seen at the Court of Appeals level, the second, third, fourth districts that have said no, these restrictive licensing systems for carry, they're fine, they're not a violation of the Constitution. Their arguments, to me as a layman, don't seem nearly as well thought out or reasoned as the arguments that we've seen from the Ninth Circuit with Peruta, from Judge Posner in the Seventh Circuit, and I think from this judge here in Palmer versus D.C., it just seems like there's a lot more thought and actual argument and opinion in these cases that have said, yeah, the right to bear arms actually exists and it means something. And
well,
here's why.
I would agree with you, and the Ninth Circuit's Peruta decision, I think, pretty persuasively walked through how the Second, Third, and Fourth Circuits, when they upheld restrictive licensing systems, like you definitely have a way you can apply for a permit. It's just your chances of getting one are slender to none. How that was inconsistent with even the legal standard that they claimed they were formally applying of intermediate scrutiny, and they omitted some of the intermediate scrutiny tests. But the Palmer decision is not one of those cases. This isn't a decision where a restrictive carry licensing system that Maryland, anybody can apply, and only a few thousand people in the entire state will get permits. This was more like what Judge Posner faced in Illinois. There is no legal way to carry, and it's an easier legal situation to say, oh, this. Look at the two cases. One is we have very severe restrictions on this right. Okay, that's one case. The other is we make it very clear you can't ever exercise this right, period, under any circumstances. That second case is the easier one for the judge. That's why Judge Posner was able to strike down the no carry law in Illinois, and similarly, D.C. had was like Illinois. There was just no way. You didn't even have the opportunity to apply for a permit.
Right. And to that end, you lay out a couple of scenarios for the District of Columbia going forward. Dave, I got to ask you, do you think it's a lock that the district will appeal this decision, or do you think they might, like we saw the state of Illinois after the Seventh Circuit Court of Appeals decision, might they say, you know what, it's better to try to come up with some sort of restrictive regime that we could get away with rather than risk fighting and losing this and taking this case to the Supreme Court?
Or actually just say that that our system to own a handgun in your own home is more restrictive than basically the vast majority of states to get a permit to carry a handgun. So we'll just we'll say we're already ahead of the game, and your ownership permit will become your carry permit. That would be the simplest thing. The anti-gun sentiment in the mayor's office is just so intense. One shouldn't be optimistic about them doing the right thing.
Okay.
And I think I think the city council is more mixed, and they've actually at times proposed some steps to make the DC gun licensing system more reasonable, and it was the mayor's office that really pushed back against that.
Yeah. All right. Listen, Dave, I appreciate you coming on the program, sir. It's a real pleasure as always, and exciting times for supporters of the Second Amendment.
Absolutely.
And best of luck with the appeal on the Colorado gun control laws. Look forward to talking with you more about that going forward, too.
That sounds great.
Thank you, sir. Dave Kopel, Research Director at the Independence Institute